Well, hi again, everyone. It's Rob Ryder, and it is Saturday, February 3rd, 2024. And today we're going to be talking about combating deceptive practices. Video one of, well, it depends on how long it takes to do this particular thing, but it'll probably be multi-videoed series. So, I am Staff Sergeant Robert Allen Rutluski, U.S. Army veteran, also known as Rob Ryder. My email address is courtofrecord@aol.com. COURTOFRECORD, no S's, right? Court of Record at AOL.com. And you can find my videos on YouTube at Rob Ryder, ROBBB, RYDER, yep, 3 B's. All right, so, in the ever going struggle to find some kind of relief, if you've been following me for any time, that way back in the day, I did videos on mortgage stuff and on tax stuff and income tax stuff and tickets and all these things. It's quite easy to find errors and omissions in what they're doing. It's just when you tell them, they don't seem to care. So, there you are. There's that. So what do you do about it? Well, there is this theory of thought that everything is commerce. And in commerce, a deceptive practice is a crime. So why not say what they're doing is a deceptive practice and see if you can get a judgment that way? Because as it turns out, you can take a business or a person or whatever to small claims court for a deceptive practice. And the fact that you can take them to small claims court changes the form of the court, that it's a different mode of trial. And so, for instance, right, this comes out of Commentaries of the Laws of England by William Blackstone. Right, it's like the Bible of law according to the founding fathers. He's talking in Book 3, Chapter 22 of the several species of trial, which then the trial then is the examination of the matter of fact and issue, of which there are many different species, right, species of trials, according to the difference of the subject or the thing to be tried, all of which we will take a cursory view of, blah, 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 blah. The species of trials in civil cases are 7. You can have a trial by the record, by inspection or examination, by certificate, by witness, by wager of battle, by wager of law, and by jury. And of course, I always tell you that your right to a jury is preserved, right? Well, then your right to all these other things are preserved. You just have to pick the one you want to use. And if you were to read this chapter, he goes into quite a lot of detail on this stuff. But like by record, that's a court of record, right? All they're going to judge by is what does the record say. It doesn't really matter what you say. What does the record say? If you want that court to find for you, you have to have the record say what it needs to say before you go there. And we know what a trial by jury is. You get 12 people together and see who they agree with, whether they have any idea about the law or not. Just, how do they feel about you? Well, what they're doing now when you go into like the big court, right, not small claims necessarily, but the big court where you have to have an attorney, that's a wager of law, where you're going to put your champion of law up against their champion of law, and they're going to go into the arena and fight it out, and may the best attorney win. But you can't represent yourself in a wager of law. You have to be represented by somebody else. And if you notice in court, no attorney ever represents himself when they go to court. They always have an attorney. That mode of trial is called a wager of law, right? And we can't win in that because we're not learned in the law. But there are these other ones like by inspection or examination. And that's what small claims does, right? Because as I remember, or as I've been told or seem to remember, I have to go find it again. But like in small claims court, you're supposed to be able to give your proof to the judge, right? So the rules are much simpler. It's much easier to get evidence into the court. And the things I'm talking about, the evidence is going to come from the person doing the deceptive act because it's all over the place. Everything that an attorney, an esquire, does, let's stop calling them attorneys, right? They're esquires. By definition, an esquire is a crown agent, right? Which makes him an enemy of the United States. So be it. right? So they're going to have to go. And, but it has to be done lawfully, legally, and we need to understand that, our enemy is not flesh and bone, it's spirit, right? And these people have an evil spirit in them, and, it's our job to bring them closer to God, and to do that, to put the fear of God back in them. And the way you do that is you have them arrested or take their money or whatever it is, right? That's what's going to make them stop doing what they're doing. But there's no reason for them to stop until we figure out how to make them stop. So I'm going to try it by small claims court. In a case to do with the deceptive practice. And in this particular case I'm going to be showing is going to have to do with a real estate transaction. Now, this isn't a foreclosure, which is part of a real estate transaction. That's one way the thing can go. But this is at the other end where the thing began. Because the very first pieces of paper in your real estate transaction is where you're going to find the first evidence of a deceptive practice. And when you're buying a house, so, everybody buys houses in a different manner. But I'm going to just pick the simplest to use because that's what we have to work with here. And so, most people, they go to a broker to go, show me some houses. And to do that, you have to sign paperwork. Well, it's one of the few places where there's actually a contract in a real estate transaction that has two parties signing the frickin' paper. Most things that you see in a real estate transaction just have your signature on it, where which is a unilateral contract, which cannot be used for business. It's not a bilateral contract. Bilateral contracts are used in business. Two parties have to agree. And that paper does exist in a real estate transaction, but it happened at the beginning. Now, one of the things that did not happen anywhere in the transaction is the bank never signed a contract with you. There's no piece of paper with your signature or the bank's signature on it. Therefore, there was never a loan. And I'm going to be able to prove that to you. And I'm going to be able to prove all these things to you. You're going to be filled with so much information on the errors and omissions in a real estate transaction that you just have to agree with me. I mean, any reasonable mind would have to say, well, that's wrong. Now, what do we do about it? So the thing to do about it, I think, is to take it to small claims court, because you can take them to small claims court for deceptive practices. And in a real estate transaction, there's this earnest money that you put up. A few $1,000. Well, that's what you're going to go after. Because as it turns out, I'm going to show you, the transaction has never been executed. Right? This hasn't happened yet. They stopped doing whatever they're doing and they started pretending. And this lady that I'm helping on her case, call her Miss Kim. Right? So in her case, it was a really new purchase, and she had been watching my videos from the past where I was showing how you could get your, find some of these different documents to look at to see what happened in your transaction. And in this case, it was the title insurance paperwork, which she got, and she contacted me, and, da-da-da-da. Now, a lot of times I can't help people with their foreclosure because I don't have an answer for that. But she's not in foreclosure, right? And she has a really new mortgage, and so they still have all the paperwork, because this is one of the things you find is that the older the transaction, the harder it seems to be to find the paperwork. Like we only keep those records for 7 years. Well, they may, but somebody else has. This is the point. See, somebody has them, and so all this stuff should be able to be found. And hopefully in the future we'll be able to do that. But I went with the easy one because wow, this lady has all the information and she's willing to go get the rest of the information, and she's a go-getter. So here, you want to go? Let's I'll show where the errors are, and let's take it to small claims court and see what they say. Because this is the other side of this. See, they then cannot afford to have this go to court. Because if they're found to have committed a deceptive practice, it's a crime. It's either a misdemeanor or a felony. It just depends on, A, B, or C. Check some boxes, and it's either a misdemeanor or a felony. But either way, it's a crime. and you're going to have a small claims judge agree with you that it's a crime, and well, now they really have a problem. So what would they have to do? Well, they'd have to settle out of court before it happens. And so that's the goal is we'll put it in and hopefully settle before you even go to court. And it may end up that you don't even need to have done the small claims case. I mean, it could be that you just go talk to the title insurance company or something like that first. I mean, that part could be figured out. But since it's so easy to put a small claims case in, well, let's just do it. Put one in. Make it for the earnest money. Say you want your money back because they never completed the transaction. And again, I'm going to show you where this is. And now they're going to have to come to court and or settle out of court, which is what we want them to do. Right? And what do you want out of it? Well, I want my fee simple title. I was guaranteed. And according to this paperwork, the loan's already been paid, so I'm not making any more payments. And so all this stuff is, you already have this. If you own a home, you already have this evidence. Well, you may not have it, but it exists, and somebody has it. And if you look at the right papers, it'll tell you where to go find it. And so if you want to do something besides, sit on your ass and bitch about things, why don't you go find this paperwork and go file a small claims case? Follow along and see if it makes sense, and then go do it. And this is how we, pierce the veil, pull the rug out from underneath the bankers, and they're no longer able to bankroll all this bullshit going on in the world, and, the world will be a happier place. Amen. So let's see what we have, right? So in this video, I'm just going to show you a bunch of stuff. Not really even any rhyme or reason. I'll just say, well, here's something, here's something, here's something, here's something. And so you probably have to watch it a few times to catch on to all the somethings I'm going to show you. Because, when you pull out a highlighter and start highlighting errors and omissions on paperwork, pretty soon it's got lots of colors on it. So, it's there isn't anything they do that they don't do without an error. It's like standard operating procedure. So let's get ready to look at something. Hang on a second. Okay, so so everybody knows where it came from, right? Like in Michigan, we have the Michigan Consumer Protection Act. Every state has some kind of Consumer Protection Act. If they don't, well, then you're the exception, right? But the rule is that they have one. And there's also the Federal Consumer Protection Act. And when you read these, when you first read them, it sounds like, well, this is something you're supposed to take your complaint to the Attorney General, and they're supposed to go try to get your relief and so forth. And I've tried that stuff before, and it doesn't work. You send something to the Attorney General, it's like going into the great vacuum and disappears in a black hole. However, you read far enough in this, it says other things, So we'll see what that is in just a second, but. Just to show you, under unfair, unconscionable, or deceptive methods, acts, or practices in conduct of trade or commerce, right? That's what we're talking about, trade or commerce. Unfair, unconscionable, or deceptive practice, or deceptive methods, acts, or practices in the conduct of trade or commerce are unlawful and are defined as follows. All right, well, that's word unlawful that's the key, right? That means it's a crime. See, normally if you wanted to prosecute a crime, you're supposed to, as a citizen, be able to go, like here in Michigan, to the district court and file a complaint. And as long as you put up the cost, if you put up the cost and it's a minor offense, then they can issue an arrest warrant. If you don't put up the cost and it's a minor offense, you just want a summons, they're supposed to go do it without putting up the cost and without having the prosecutor involved. But they won't let you do it. Right? So there isn't any other court that allows you to go and file a complaint for a crime. But my gosh, you can do this in small claims court. So you can take and get a ruling from small claims that what somebody did was unlawful, and they cannot afford to let that happen. So they're going to have to settle out of court. And if you go far enough down in here, then action by person for declaratory judgment, injunction, or actual damages, right? These are the different things you can try to go get. But the problem is when you go to the big court where you need to be represented by an attorney and you're not, even though you're pro se, I don't know that you can get a declaratory judgment from them. You can try, but what you can do is go for actual damages in Michigan, right? And take them to court. So if we're talking the escrow, or not the escrow, but the earnest money, well, that's in Michigan $10,000 or less. You can do it. But you could just take it for the actual damage of $250 because you're really not, you'll take the judgment from the court, but the idea is to get them to settle beforehand, right? And put this in, and 3 days later be done. That's what I'm talking about, right? Not go to court to argue the fucking thing. Let's just get it settled. So this is, while most of the act is all talking about what the Attorney General can do, they slip this and they say, but you can do this also. Right? Obtain a declaratory judgment that a method, act, or practice is unlawful under Section 3. Well, that would be the judge admitting that what the dude did was a crime. I'll take it. Right? And join in accordance with principles of equity a person who is engaging or is about to engage in a method, act, or practice that is unlawful under Section 3. Okay, I'll take it. And under Section 3, list all the different things that, can be considered. And, let's just look at, here's a deceptive practice, just for an example. If you get a piece of paper, like this complaint, it's got some Esquire on there and it looks like the name of some company and da-da-da-da, well, that's a deceptive practice. Right? Because there is no attorney in this state named Victor Spinelli. Right? If you were to go look at his roll of attorneys or something, they'll have some other form of name on there. Now, this Fine, Such, and Crane LLP, they probably are registered with the state. They have a state license to exist. So because they do, you can look them up on the state website and you can find out who their registered agent is, and you could take them to court for deceptive practice for having somebody without a license act like an attorney. Because Victor Spinelli Esquire does not have a license. Right? Victor Anthony Spinelli, he may have a license, but that isn't the name they used. And a lot of times you'll see a name there with a middle initial on it or something, and that's not your full legal name, right? Everybody who watched my videos enough, you know. If you don't know it yet, you better learn, right, that you don't have a middle initial. Right? You don't even have a middle name. In my case, my first name is Robert Allen. So I can't have a middle initial. And why is that? Well, because that's what I say. It's my name. My first name is Robert Allen. I can have a two-part first name. There's nothing they can do about it. But what they're doing right now is they're doing this deceptive practice, and then they get you to go to the court where it's going to be trial by wager of law, and their attorney is going to go against you, pro se, your attorney representing you, and wipe the floor up with you because you don't have a damn clue about all the ins and outs and secret handshakes and all the other shit they do. Right? So this is a foreclosure, but it doesn't have to be a foreclosure. It could be anything that, you're getting served by some attorney for something. Just go look the company up on the state records, find out who their registered agent is, and that's who you're going to serve the lawsuit for deceptive practice that you're going to open in a small claims court. That's what I'm talking about. So now, that's if you had a foreclosure. This is what we're going to talk about today is not even to do with the foreclosure. This is just if you own, a house. And if you own a house, I ask you, to go do this, to go and get the information and go file a case because you don't need to be in foreclosure. You shouldn't be paying anyways that you didn't sign a contract with the bank. And just one more proof on this. This is what they say in Illinois about a deceptive practice. He or she knowingly causes another by deception or threat to execute a document disposing of property or a document by which pecuniary obligation is incurred. Well, that's the thing they call the deed of trust, the mortgage, the note, all those pieces of paper are a deception because you didn't sign a contract to the bank. So this goes on. Oh, and then bad checks. So here's the other thing they do, right? They take your note that you give them in your transaction, and they convert it to a check by putting a stamp. They endorse it with a stamp that says "pay to the order" on it. And anything that says "pay to the order," that's a term of law used on checks, drafts, and orders. I believe it is. Right? All things that can be paid to the order. It's a frickin' check. And by doing that conversion, right, they've just paid themselves. Or they've unlawfully converted your check, and now they have a bad check because it doesn't have any value, but they turned it into a check. You didn't do it, they did it. You're not going to see this on the note that you gave them, but they endorsed the back of it. When I was doing the foreclosure videos back in the day, you would see when they put in these notes, right there, they got an endorsement on it. It's been turned into a check. And we've told that court, but they didn't care. Well, that court was, the trial was by wager of law. We need to get out of that. We needed to get into the one that's more like, what did Blackstone call it? Inspection or examination. All right, where you're going to go to court and say, Judge, would you look at this? Right, this is what they did. I say this is deceptive practice. But, that's if you ever made it to court. There's every good reason that they don't want to go to court, and they would have to settle out of court immediately. So let's find out. But what I want to show here is in Illinois, they tell you what the sentence is. The commission of a deceptive practice is a violation of this section, except as otherwise provided by this subsection, is a Class A misdemeanor. But if you do it bad enough, well, it can be a Class 4 felony. Class 4 felony, right? So you can either have a misdemeanor or a Class 4 felony. Well, take your pick. Either one, you go to jail. So either they could, negotiate to settle the matter ahead of time, or they could go to court, get a judgment against them, go to prison, and then the judge will settle it for them. Which one do you think they're going to pick? Well, there you go. I mean, they did go to law school after all. They should know the difference. Oh, man, we've been caught. It's time to beg for forgiveness. Well, okie dokie. Yeah, it took 22 minutes to get into talking about something. But now let's look at something. So, if you wanted to do this, right, you want to start, if you can get these 4 pieces of paper, it's a good place to start, which is the Uniform Residential Loan Application, the closing disclosure, the contract you had between you and the seller to buy the property, and the contract you have between you and the broker for the broker to represent you. And this is where we're going to start with this one, right? Because this is like the first piece of paper you would do in the transaction is you go to the broker and say, you're looking to buy a house, and well, just sign right here and we'll help you find one. Right? And so this says the kind of stuff that's supposed to happen, like at the closing, right? They're supposed to transfer the legal title. Legal title to the property is conveyed to the purchaser. All right. Property means interest in real estate. Okay, so you got rights, titles, and interest. So property is the interest, but legal title to the interest is separate from the interest. It's the title, right? Rights, titles, and interest. Hang on a second here. And if we look here, broker's fees, right? So the parties agree that the broker will receive a commission calculated as follows. 3% of the gross sale if the client agrees to purchase property in the market area, and if the client agrees, and 50% of 1 month's rent. I got 1 and a 2 here. The source of commission payment. Broker will seek to obtain payment of the commission specified in paragraph 11A, first from the seller, landlord, or their agents, which the seller had an agent also. If such person refuses or fails to pay broker the amount specified, client will pay broker the amount specified, less any amounts broker receives from such persons. So that's the first question. Did the broker get paid? Right? Because as we're going to see, this deal isn't done yet. There's something keeping the deal from being done. And one of them would be, well, the broker didn't get paid. But the broker is supposed to have done certain things before he gets paid, which is what this earn and payable is. Right? A person is not obligated to pay a broker a commission until such time as the broker's commission is earned and payable. So one of the things that the broker is doing for you is he's acting as you. And there are certain things that you're supposed to do then as the buyer on the agreement you're going to have with the seller. But it really isn't you that's supposed to do them. The broker's supposed to do them. And did he do them or not? And if none of this stuff is happening and it isn't done yet, then say, hey, I want my earnest money back. All right? The amounts payable to the broker are to be paid in cash. Well, not by check. Paid in cash. You got to walk up to the guy with a wad full of dollars. This is the thing. And you got to do it in Harris County, Texas. Not the county of Harris, state of Texas, but Harris County, Texas. You got something about mediation, good faith, and yada, yada, yada. Anyways, you get to the end, and, sure enough, somebody signed for the broker and somebody signed for the buyer. And again, the seller has their own one of these, right? So this is really a contract, right? This is a legal contract. And so now people have to do what the contract says. And if they didn't do it, well, it's a deceptive practice. It's really that simple. Well, what's supposed to happen is they're supposed to, at closing, have transferred the legal title. So if you don't have it, the closing never happened. So how come the buyer didn't close? The buyer being the freaking agent. Right? He's supposed to have closed. You may be doing the signing, but the transferring of the title and so forth has to be done by a broker. All I know is, if you don't have legal title, then something happened, and because that's what was supposed to happen at closing. That's the number one thing to get out of this document is, well, at closing, you're going to get legal title. And if you ain't got a legal title, then you ain't got anything. Okay, so from that, then, though, you do a contract with the seller, right? In this case, the seller was a new home purchase, right? So, and where it is and so forth, and what's going to happen, and there's going to be some earnest money, right? That's the buyer must deliver to University Title Company, right? Escrow agent. And we're going to find out in this that University Title Companies were wearing maybe 3 hats, could be more, but they're the escrow agent, they're the settlement agent, they're the title company. There's, got lots of hats going on for $3,700. Okay, so if you gave them $3,700 and this deal didn't happen, well, then that's a deceptive practice. You want your $3,700 back. So, I'm going to jump ahead now because a lot of this stuff we're already doing on this case, right? And Ms. Kim said that these people, between the bank, the title company, so forth, they're kind of, they're probably all binge drinking this weekend because they think they're learning they've been caught in a fucking, in their own lie. But we'll find out, right? So anyways, it's about the $3,700. Who's going to give me my money back? Because one of the things that you can do if this deal doesn't go through is you can contact the escrow agent and say you want your escrow back. Right here, the amounts escrow agent receives on this paragraph should be applied first the option fee, then earnest money, and then additional earnest money. Delivery option fee to the seller anytime without further notice until to the consent of the buyer. And release of escrow agent from liability from delivery of the option fee to the seller. The option fee is credited to the sale price at closing. So what's this option fee they're talking about? All right, $140 as an option fee. I have not seen yet where that is, but apparently it had to be paid someplace. So, there's just so much stuff. Look at this. It's hard to keep up with all the things that are wrong. And then you go down a little further, and we're down now to the title policy. The seller shall furnish to buyer at seller's expense and owner's policy of title insurance, would be a title policy, issued by, well, there's University Title Company again. And now they're the title company. Or up here, they were the escrow agent, right? That's put on a different hat. Now they're the title company. So they're supposed to have provided, let's see, in the amount of the sales price dated at or after closing, insuring buyer against loss under the provision of the title policy, subject to proclamated exclusions, including existing building zoning ordinances and the following exceptions. Okay? So then within 20 days after the title company receives a copy of this contract, seller shall furnish a buyer a commitment to title insurance. So Miss Kim, this is what she had done first, right? She had watched the video I talked about how to get your title insurance policies. Don't ask me what it is, a long time ago, right? But that's why it's just easier to get these documents first. And this is how you get it, is to have these documents we'll be looking at here in just a second. But it's the title insurance company. So contact them and say you want a copy of it. And she did, but she didn't get anything that said it's a commitment. Right? So this is one of our next questions to them is, we asked this title company, because they're the closing agent and the escrow agent and the title company, did this deal close, and where is my commitment? And that was at the end of the day yesterday, and we'll see what happens on Monday. But, you would take this question to the title insurance company. Hey, where's the copy of the commitment I was supposed to get as the buyer's title insurance policy? So within 20 days after the title company receives a copy of this contract, seller shall furnish the buyer a commitment for title insurance, and at buyer's expense, legible copies of restricted covenants and documents evidencing exceptions in the commitment exception documents, other than the standard printed exceptions. Seller authorizes the title company to deliver the commitment and exception document to buyer at buyer's address shown in paragraph 21. And the only address that was in there was an email address. And Miss Kim didn't get any of this stuff, right? She didn't get copies of these. She wasn't told she could have copies of these. And, like I said, the great thing about hers is it was a case that started in 2020. She bought the property in 2023. So this is all still fresh in her mind. It's not like 10 years ago type of stuff, right? She got pretty well locked in what happened and what didn't happen. And but this is how you find out. Well, let's go ask him. Okay, where's the commitment? If the commitment and exception documents are not delivered within the time required, buyer may terminate this contract and the earnest money will be refunded to buyer. So asking for your money back. Because it didn't happen. But that's the thing. You could ask them, I don't want my money back. I'm going to go get it from court because I wanted this whole thing to be done. And, it was a deceptive practice. You told me, because they've told you, right now, you're believing that you've closed and because you're living in the house. Well, the closing never happened. That's why you pay taxes, because you're renting the property. Survey. The survey must be made by a registered professional land surveyor acceptable to the title company and the buyer's lender. Then they had to check one. And it says, within 15 days of the effective date of this contract, buyer shall obtain a survey at the buyer's expense. Buyer is deemed to receive the survey on the date of actual receipt or the date specified in this paragraph, whichever is earlier. Okay, well, Miss Kim didn't go ahead and she didn't get a survey done. But in reality, the buyer is the frickin' broker. The broker is supposed to get this done. You may have to pay for it, but he's supposed to be, doing this deal for you. He's your agent. So if he didn't do it, right, it's a deceptive practice. Objections. Buyer may object in writing to defects, exceptions, or encumbrances to title disclosed on the survey other than items 6A through 7 above disclosed in the commitment other than Now, the title they're talking about, you know what this really is? It's a map. It's like a cadastral survey. And so we're going to see what one looks like in this case. It doesn't have her name on it, but this is the difference. It's a survey that has the name of the owner on it. And, and surveys that go with mortgage loans that people find and see, they don't have the owner's name on it. That is your title, right? When your name is on the plat map, saying you're the owner of this thing that's been surveyed by a professional surveyor and then recorded in the county, well, then you're the frickin' owner. But there isn't one. Title notices, abstracted policy. Broker advises buyer to have abstracted title covering the property examined by an attorney at buyer's discretion, or buyer should be furnished with or obtain a title policy. Well, that should have happened already. Or buyer should be furnished with or obtain a title policy. Well, I believe that's what we were supposed to have done up here, that this is what the title policy was supposed to have come from the seller to the buyer, and the buyer was supposed to have gotten a commitment within 20 days and copies of any restricted covenants. Got to pay for them. Please pay the money. I want the restricted covenants. Because if they don't give you any, well, then there's no restricted covenants, no matter what they're saying. And it's the restricted covenants that you're paying tax on, right, that make up your ad valorem taxes. Well, that's because you don't have the damn paperwork you need to prove that you don't have to pay that stuff. Statutory tax districts, if the property is situated in a utility or other statutory created district providing water, sewer, drainage, flood control facilities and services. Didn't say electric. Water, sewer, drainage, flood. Seller to deliver to buyer to sign the statutory notice relating to the tax rate. Bonded indebtedness, a standby fee of the district prior to final execution of the contract. So anyway, there's all sorts of, interesting paperwork you should have gotten that you probably didn't. And it goes on and on and on. Broker's fees, all obligations of the parties for famous broker's fees are contained in a separate agreement. Right? We read that already. Closing. The closing of the sale will be on or before January 31st, 2023, or within 7 days after objections made. And, Ms. Kim believes that she closed because she went to a closing table, but she don't have a title of the property, which we read on the other document. All right, let's go back and look. It's just good to, know where the stuff came from. Closing. In the sale transaction means a date, legal title of the property is conveyed to the purchaser. Didn't happen. But, what did happen is possession. Possession is 9/10 of the law. It's everything but legal title, and that's what the difference is, right? The legal title is what was supposed to happen at closing. Seller shall deliver to buyer possession of real property in its present required condition, ordinary wear and tear accepted upon closing and funding. So if you're in there, apparently these things have happened, so there must be a deceptive practice going on. Settlement and other expenses. Anyways, just all sorts of things. It should have happened, didn't happen. You got escrow. The escrow agent is not a part of the contract, so that's the title company as the escrow agent. It's not necessarily the title company as the title company, but the title company as the escrow agent. Which is why it's important to realize that they're wearing more hat. They're going to say, well, no, we're the escrow. Yeah, I know you're the escrow agent, so you're not liable, but you're also the title company, so now you are liable. Demand. Upon termination of this contract, either party or the escrow agent may send a release of earnest money to each party, and the party shall execute counterparts of the release and deliver the same to the escrow agent. Right? Because all your money that you're putting in when you make payments on a mortgage go into an escrow account. They don't go pay off a loan. You didn't sign a contract. There is no loan. They're going to an escrow account. Right? And it's being invested, and somebody's living off that shit. And, in 100 years, when you're dead, well, then somebody will be able to collect your property because you abandoned it. Right? You're no longer here. You didn't take it with you. But until then, they get to live off the interest. This is, an ongoing scheme that's probably been going on for 2,000 years. It's nothing new under the sun. It's whatever the Pharisees were doing back in the day. Same thing is happening today. And, forked tongues, telling two stories, not telling the truth, taking advantage of their brother, not living by the golden rule. That's what we're dealing with, right? In a Christian nation, every transaction would have to be done by the golden rule, where you can't take advantage of somebody. Well, that ain't what happens in the United States. It's all about taking advantage of somebody, right? That's the Jewish system. That's the Judeo system, where it's perfectly fine to cheat somebody at law or in business. But that isn't the Christian system, where you cannot take advantage of your brother. And not just your brother, you just can't take advantage of anyone, period. So any party who wrongfully fails or refuses to sign a release acceptable to the escrow agent within 7 days shall be liable to the other party, and so forth and so on. So you could write and say, I want back my escrow money, right? Who to? Well, I guess to the escrow agent, which is the title company. And write them and say that you want it back. This is my written request to return my escrow. We're not going to close the deal. I'm going to take you to court for deceptive practice. Let's see if that gets them to do something without even needing to file a court case. Representations. All covenants, representations, and warranties in this contract survive closing if any representation of seller in this contract is untrue on the closing date. Seller will be in default. Well, if the seller didn't get a what would they call it? What was that thing up here called? At the broker's fee. Way at the beginning. The commitments, right? Within 20 days after title company receives a copy of the contract, seller shall furnish to buyer a commitment of title insurance. If you ain't got it, well, then the seller defaulted. Now, the seller also has an agent that's acting for the seller. And they're not on this contract, but they'll be on a different thing we're going to look at here in just a second. But these are the two pieces of paper, or the two forms that you do with the real estate agent. All right, buyer's attorney is, nothing there. Oh, there we go. Both parties signed this. So they both agreed, right? The buyer and the seller did. Well, here we go. So broker information, right? Real Broker LLC. And seller's agent. So here it is. Here's the seller's agent's information. Right? Take them to court. They violated the seller. If the seller did not give you a commitment within 20 days, they violated the terms of the contract. So, which one of these people you have to push first to get all to divide Satan's house? Because everything they're doing is the devil's in the details, and that's where the errors are. So once you point out the errors, the fingers start pointing. And once you do that, well, now the devil's house starts to fall apart. So, which one of these people we poke at first? Or do we just poke at all of them at the same time? We'll have to find that out. Right now, we're just gathering evidence, right? I hope you're starting to see that there is such a thing. And we're going to take it to a court where they examine the evidence, not a court that does trial by law, where you need to be represented by an attorney and they're going to go and fight it out. No, we just want to get it decided. Let's look at the evidence and see what, and then examine the defendant and find out, defendant, what's your story? Okay, so this is for the land side. This is what this is. But there's this other transaction going on at the same time, which is the money side, which has nothing really to do with the land side, because, there wasn't a loan in the first place. It's the money side. So let's do this. Let's look at the closing disclosure first. at some point before it all gets done, you're going to have been given one of these, and you're going to start seeing, well, they're giving you all sorts of wonderful information. Who's the settlement agent? Well, that's the University Town Company. So they're the settlement agent, they're the escrow agent, they're the title company, and they have a file, right? So, you'd like to get a copy of that file because it's about this particular case. And because it's on here, it's, incorporated by reference. It isn't here for you to look at, but by the fact that it's been referenced, it's incorporated. So you get to look at it, but you got to ask for it. And then we see that the lender is supposed to be this Wallach and Volk, and that they got a loan number, and it's supposed to be FHA, and here's a MIC number, which has something to do with insurance, also because of the FHA. And so, like Wallach and Son Incorporated, if you went to Texas and looked them up on the Secretary of State's website, you would see that they have license to be a mortgage lender. In fact, let me get that because I already got it. Hang on. So, right, the state of Texas. I like this, first of all. Not just state of Texas, the state of Texas proper name, not just state of Texas. I think state of Texas is the Civil War name, which is the name they use now because we're still under martial law of the Civil War, and they should. It's why they're the Lone Star State. They're the one that didn't go back to the Union. Nevertheless, in the state of Texas, right, the entity is a foreign nonprofit corporation named Wallach and Volk Incorporated, right, and they are here for mortgage lending. Okay. So, they have a license to do business in the state, and you keep looking, you can find out that they're registered and that this is their registered agent. So if you had business with Wallach and Volk, right, legal business, you wouldn't serve 222 East 18th Street, Cheyenne, Wyoming. You would serve 919D North Valley Mills Drive, Waco, Texas. Okay, so, they got a loan ID, so you could contact Wallach and Volk, say, hey, I'd like a copy of everything in loan ID, this number, and MIC, this number. Why? Well, because you're a party to the contract. You want to look at it. Which they didn't like much. I mean, they're not liking this much there in Texas right now. Let's see. We've got all sorts of stuff in here. But this is the biggie stuff. Then you get down to contact information. Right? The lender, the mortgage broker, the real estate broker, right? Got one for the buyer, one for the seller, and the settlement agent. And then they give the addresses, and then they give this NMLS ID, the number, and a Texas license ID. All right, who the contact is, contact NMLS ID. Contact, there's actually two people here. You got the company, then you got their person, right? This is two parties involved in this lender thing, but they're claiming to be the lender. And there's a site you can go to, put in this number, and you'll get something that looks like this, right? The NMLS Consumer Access, right? So if you just Google NMLS, you get taken to this site, look for the link for Consumer Access. You can put in like this NMLS number, and it'll pop this up and tell you who they are and where they're licensed, right? There's Wallach and Volk. And it says Texas mortgage banker registration. But it doesn't say license. Right here it says in Tennessee they got a mortgage license, but this doesn't say they got a license. They just registered. Well, I believe if you want to do the business, you got to have a license. And if we go back and look at the document, it says that they got a state license. So then you contact the state, say, Open Records Act, I'd like a copy of this, whatever's in this file for this license, which we've done, and now we're waiting to see what comes back. But all these people have a state license, right? So you could do it for every one of them. Get their license and see if they're licensed to do the thing that they're doing. Because if the Wallach and Volk isn't licensed to be a banker in Texas, and they can't lend any money. proving that there was no loan. And then they have this other person, right? Let's look at hers. So this is really good, right? Because it says this is for Lisa Alonzo, the contact. Well, when you look hers up, it's for Lisa Ramona Alonzo Mrs. MRS. Nowhere in here is it for Lisa Alonzo. Even with all these other names, there's not one of them says Lisa Alonzo. So the person doing this isn't using the name that's on the license, right? They misrepresented themselves. Lisa Alonzo doesn't have a contact NMLS ID. But she's supposed to have, and she's got this contact license. So, I mean, this is just a deceptive practice, right? I mean, how much more deceptive can you be that the person with the license is Lisa Ramona Alonzo, but that isn't the name they're using to close this? Well, that's just like the attorney did on the foreclosure. Using one name and having another name licensed. Well, it's the exact same with the rest of these people. So, it's just a matter of filling out the form and waiting. Send it to the state. Say you want the records that go with this license number. And this license number, and this license number, and this license number. But then you go to the bottom and, well, the applicant never signed it. So really, although this information's here, nobody ever agreed that this shit was reviewed, right? This wasn't reviewed by the buyer. Additional escrow about, okay. Some escrow money is $9,000 is going to be escrowed, so there is money in the escrow account to say, well, I want my escrow back. So they give you this paper. I mean, this is how you would, if you have done a transaction, especially recently, and they're doing it this way with the paperwork, you're going to have this someplace, and it's going to look just like this, with its own errors and omissions on it. Right? So that was that. And then the other one is the Uniform Residential Loan Application. I think there used to be called a HUD-1 statement or something like that. But, and look, it's got all this stuff on it. Just start looking. Well, what does it say? Well, there's an envelope somewhere. Well, I want a copy. Right? This part's supposed to be completed by the lender. Has this number and this number. Well, I want a copy. Right? Because this is actually two things. The lender loan number, which is up to the slash, and then the universal loan identifier, which is something else. It's like, well, where's that at? So you got to make sure you've asked for both of these and see exactly what they are. But that's why I'm just asking for everything. Right? I'm using these documents to find the things to ask for. That once you find them, you'll find the proof inside of them, other than what we're going to find in these already. That, bury them in their frickin' deceit. Like they use the middle initial name, right? Well, the borrower cannot use a middle initial name because it's a legal document. You got to use your legal name. If you want to use a legal fiction, that legal fiction had to have been registered with, like in my case, in the county before you can use it to do business, because they want to know, well, who we doing business with. And there it says U.S. citizen, and Title 15 will tell you a U.S. citizen is a business. It doesn't say citizen of the United States, like the Constitution. It says U.S. citizen, which is U.S. is Civil War terminology. So, it's you and your business. So this is all commerce. Okay, it's all about commerce. Got it? In commerce, you can be charged in small claims court for deceptive practice. And if the judge agrees, then he's just agreed that you committed either a misdemeanor or a felony. They don't want to do that. They can't afford to get that judgment. I don't think most of the stuff has to do with you, and it doesn't really matter. This is not so much to do with the buyer. It has to do with the lender or the other party on the contract. Because we're going to go... Hang on a second. It is set up for scrolling. Okay. Loan originator. Well, it says the loan originator is Wallach and Volk Incorporated, but that isn't what their license said. They're supposed to be a mortgage lender. It's a different license to be a loan originator than a mortgage lender. So unless they have a license to be a loan originator, then that's a deceptive practice. That's why we got to see, well, what does this ID have to say? And then a loan originator name, right? This is Lisa Alonzo. Well, that isn't the name that's on the license we looked at, right? By looking at this number here. Well, we haven't seen their license yet, but here are their license numbers. So you ask for them to see if they have a license to be a loan originator or not. And if they don't, or if one of them doesn't, it's a deceptive practice. And this will blow you away. So now this is the page for that this section is completed by your lender, right? So this is them telling you what's going on. Transaction detail. Look at nothing's been checked. There's nothing going on. Right? Title information. Title to property will be held in what names? Kimberly R. Price. Well, that's really not her full legal name, so it shouldn't be there. And it says the estate will be in fee simple, but which manner will the title be held? And there's nothing been picked. Right? There's nothing that shows how it's going to be, if it's going to be held as a sole ownership, as a life estate, as a tenancy in common, as joint tenancy of the entirety, or other. Nothing has been picked. We know what name it will be in, but not what style it will be held in that name. So there's no title that's going to be transferred according to this document. Yet that's what you agreed to with the real estate transaction. So this transaction here must not have a damn thing to do with the real estate transaction because there's no title being transferred. Or it's a deceptive practice. Right? Mortgage loan information. FHA. Okay, fixed rate. But none of this other stuff is filled in. It's like, well, where's the FHA loan? Do you have a loan signed by the FHA? Because, I thought that the bank was supposed to be your lender. Right? Volek and whoever it was. I mean, that's what they're saying they are. Right here, they're saying that they're a mortgage lender. So somebody had to sign a contract with you, and either it's these people here because they say that they're the lender, or it was with the FHA who would have to have sent an agent, and they would have had to sign something. But, there's nothing been signed. Okay, so now we can look at, this is going to run a little bit more than an hour, but I just want to show some of the documents that we have found because we have asked for these things. And let me pull some of those up. Hang on just a second. I want to go back real quick to this contract between the buyer and seller because I didn't go down all the pages, right? We got to this where we're talking about broker information. And see, they got a license too, so you can get that license, make sure they're who they say they are. She's got a license. Yeah, I want that one too. All right, license. But look, you go down here farther, and earnest money receipt. It's blank. Yet, one of the documents we got was a document that shows that there was a receipt, or it shows that there was a check received by Universal Title Company, right, for $3,700, which was the earnest money. So, because the agent is acting as the buyer, it looks like you're supposed to have given it to them. They give you a receipt, and then they go give it to Universal Title. But that didn't happen because there's no evidence on here that they ever got the earnest money. I'd say that's a deceptive practice. Okay, so one of the first things was that Miss Kim got this here, which was she asked for the title insurance information, right, for her property from Universal Title Company, and they sent her this. But as we see, it doesn't say it's a commitment anywhere. It just says it's Schedule A. And the interesting thing is, it gives this legal description here, and then it gives this film code. And if you click on this, it takes you to their business website's list of these maps, not the county, right? So you wouldn't be looking at the county, you'd be looking at their own system. And when you do that, this map here comes up. All right, which is showing we're talking about this right here. And it's got all these stamps, 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 stamps. Look at that. What did I highlight over here? Let's see what this says. This is the meat and potatoes here. Right? Owner, which is the people that Ms. Kim is buying from. It's not necessarily her, but this does have an owner out there saying that they own that. And this has been recorded. This is page 1 of 2, right? Done by Bowden Survey. Well, because this document has an owner's name on it, and it's a survey. What are we doing, man? We're drawing, we're identifying a particular piece of land with 4 squares. We're going to enclose it, and then, call that what we're calling. This is what we're talking about, and that's what the owner owns. Right? You don't have something like this right now with your name on it with an arrow pointing to a lot saying you own that. Right? Neither does Miss Kim, but the person before her has one that shows that. And this is an intentional thing that's done. This is like under the Torrens Registration Act, where they'd always be like one step behind with the registration. Who actually own the property? It's always the person that just sold it that they're making the owner of the property. Because the owner of the property, whoever this was before, they sold it. They have no idea this shit's going on. They've moved on. So, and then the second page of this is a tax certificate. And Harris Bennett, Harris County Tax Assessor Collector. Right? Certificate fee, $10. There you are. Pay the certificate fee, get it certified that you're the owner. Right? Because who's the certified owner now? Quincy is. And this should say certified owner is Miss Kim, because she's the owner. If she was the owner, then she wouldn't have to pay all this bullshit, ad valorem tax she's paying. But she's not the owner. She's just a tenant. Because none of this stuff has ever been done. And the other thing is this legal description here doesn't match the legal description that they used on the map or that they used in the title insurance. Let's look at that. Where is that title insurance at? Right here. Right? Lot 1, Block 1 in Brentwood Estates, a subdivision of Harris County, Texas. Well, I think what this is, Lot 10, Block 2, Shadydale. Yet when you look at the map, no, it's Lot 1, Block 1 of Brentwood Estates. And they, this was an intentional error put in the record, so when you go to look it up, you don't find what you think you're going to look for, what you're going to find. So actually, when you use the information that you were given to go look for the map, like this number here, where is that? Right, because if you take this number and you go to the county's, records where like real estate records are and so forth, and they have a place to put in field code number, but they're telling you that this is actually a book and a volume and a page number, 698-887. That's what they're telling Miss Kim. So she put the stuff in, and when you do it the way they tell you to, you come up with this map here that has nothing to do with the property that she's buying, or it's got a different legal description. But down here, where it had a stamp on it someplace, all right, 698-888. And so this other page, if it had been properly stamped, would be 698-887. But it's not the right one. So it's like, again, it looks like this stuff is obviously being done intentionally to keep the truth from being known. Okie dokie, so back to the owner's policy. Right, most of the stuff on the policy itself isn't really of any interest right now because there's no commitment paperwork. But what there is, you go all the way through this and you get to the end of this thing. Right? Because this is, when she asked for the documents, this is what they sent her. So they're saying all this is the paperwork by the title insurance company, which is also the title company, which is also the settlement agent, which is also the escrow agent, them people, at the end of her alleged insurance policy is a copy of a general warranty deed with vendor's lien in favor of third party and so forth and so on. And when you read this damn thing, it says here, receipt sufficiency, which hereby acknowledged, unconfessed, and further consideration, advancement payments in cash, all in part, purchase price here for by beneficiary at special interest request of grantee under certain note, principal sum of payable to the order of these people here. Right? Well, anything that's payable to the order, that means they were given a check. So, whoever got the check got paid. This thing's already been paid. And it goes down here and says the same thing again where it talks about being paid. Because there was actually two of these in there. Payable to the Texas Department of whatever. So they take your note and turn it into a check. And this is just, more proof that that's what's happening. Okay, so that title insurance paperwork, that would come under this file number right here for settlement agent, Universal Title Company, right? Whatever they have in that file, you want to have a copy of. And so I don't know if we got everything yet or not, and Ms. Kimmons going to go back and ask for more. Maybe she already found out. I don't really remember. But the next one is the lender, right? They have a loan ID number. Well, you want what comes in that also, and that's what we're going to look at next is what she was sent. And they weren't really happy about doing it at the time, but they ended up doing it. And so, it's pretty long. We're not going to be able to go through all the pages. I'm just going to show you a few pages that stick out to me that they had this notary certification in here, and they're using a notary from county of Bexar, but this is the county of Harris. Right, so I hereby certify in the panel of Persia, I'm authorized to act as a notary public in and for the above county and state, and that in performing my duties as notary public, I have complied with all applicable state, local, I haven't presented original government issued identification, blah, blah, blah. But this isn't happening in Bexar County. This is happening in Harris County. So, does the guy have any authority in Harris County, or did they intentionally, by deceptive practice, use a notary from a jurisdiction that has nothing to do with the jurisdiction where the land is? Or did all this shit actually get registered or recorded in Bexar County also? Right? Why is it Bexar County? How come it was Harris County? Right? Good. Yeah. Houston is in Harris County. But that isn't what we're talking about here. Okay, so these we already looked at, but hang on a second here. Go to the next page. Enable scrolling. 14. Seller or purchaser borrower statement for escrow. I have carefully reviewed the HUD-1 statement. Well, it's not signed. Ms. Kim signed it, but it wasn't signed here, and it wasn't signed by the settlement agent, so this is this is coming from the bank. This paperwork isn't done. The HUD-1 settlement statement was not signed off by everybody, so it's it's just a piece of paper at this point. It's not a legal document. This is a contract. If everybody had signed this, they would all agree that it had been done, but nobody signed it other than Kim. Texas disclosure. What do we got going here? Now we got settlement agent. Right? That's where we get that they're the settlement agent, and the title agent is University Title Company. The underwriter is National Investors Title Insurance. Fees paid, none. Portions Real Estate Commission disclosed. Disclosure will be dispersed to nobody. And it's not signed. Right? So we have all this paperwork that the bank has. This is supposed to be the people that lent you the money that you're supposed to be sending checks to, that are doing all their business based on documents that haven't been signed. Well, Come on now. You know that's a deceptive practice, right? Property address. What that was so big deal. Here's the note. Now look, on the note it says, I will make my monthly payments to this P.O. box. Right? Or a different place if required by the note holder. Now who's the note holder? Doesn't matter. It said to send your checks here until you're told to do different, right? To this P.O. box. And so what Miss Kim said is for the first 2 months, she sent her checks to that address. And then she was told to send them to another address, to a completely different bank. And that's when she, said, hey, there's something going on here. She started doing some digging and started, watching my videos. And one thing led to another, and here we are today, right? But why? Well, because after 2 months, she was told to send her check to somebody else. When it says here to send it to here, but they didn't say just to send it to a different address. They said to send it to a different company, which I don't know that I have their name here, but, there's another finance company involved in this thing now. So really, if you're not sending your checks to that place there, and which is Warwick and wherever the hell they are, Wallach and Volk, this is their address. If they didn't tell you to send them someplace else, to them, then they send it to somebody who doesn't have anything to do with the contract. Right? Your contract is with Wallach and Volk. It's not with whoever the other agent was or the other finance company that got involved. Yet they're trying to make it seem that way. First payment letter. Right? Here's the checks going out to this address. And then they started going somewhere else. Or they wanted them sent somewhere else. Okay. That was it on that one. Now we're going to go to page 48. The addendum. What are we looking at this for? I was clicking the wrong button there. Hang on a second. All right, FHA case number. So apparently FHA is involved, and where's the file? Right, the FHA's got it. So another thing to go looking for, mortgagee ID number. Right, so this is how they're identified with FHA apparently. Not that I know what that is yet. I just know, well, now I know who that number goes to. So now we can go ask for a copy. Right? 512, whatever that is, you want a copy of it. We'll go from there to 51. 2. All right, but see, that's a 3-page document, and we get to the 4th page here. Right? Wasn't signed by the mortgagee. Wasn't signed by the underwriter. Wasn't signed by the direct endorsement underwriter's signature. Nobody signed the damn thing. Right? Nobody's agreed that the HUD form is proper and done right, and none of this is going to happen. It may have been the intention at one time that was going to happen, but they just stopped doing the fucking paperwork. Right? So this is the, what do we call this? The HUD addendum to Uniform Residential Loan Application, which has got a number here. It's the HUD form 92900A. Nothing there. And then we go, it's okay, it's got more pages. Nobody signed this page, right? Blank, 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 blank. 4-page document. Not signed by anybody. I mean, this is just chock full of evidence. Well, there's something going on here that's a deceptive practice because we don't have an agreement. But you got me to sign some kind of paperwork, so I'm going to give you this money, right? See what you did by giving them the note is give them a unilateral contract. To say I'm going to give you this money, but it has nothing to do with the property, with the land. They just running these two schemes side by side. One where they're going to say they're going to give you the title and never do. The other one saying, well, this is what you got to pay for it, but there's never been a loan. That's Esquires for you, people. And then what did I say? 62. No bank signature, right? Notice of no oral agreements, okay? But guess what? The bank didn't sign it. And, there's just, God knows how many more are like this. I was just trying to go through all this stuff last night. It's just too much paperwork to look at. TMI, man, too much information. But I'm glad to have it. Now I got time to go through it, and I want more. There's other ones to get. And we're going to air their dirty laundry for everyone to see. Shine a light in dark places and scare the shit out of the devil. Okay, we got this thing called a subordinate lien in here. Make sure this is going to scroll. Yeah, it should. Why did I do that one? Subordinate lien 94 through 104. I think as we're going to find out it wasn't signed or something. Let's see. Right, so you have this whole, supposed to be a deed of trust, basically. Right, and you get down here, signatures follow, and there's nothing on this page. Then you go to the next page, and they got one signature for Miss Kim, but apparently it was done in Baxter, but nobody else did it. You had all these other spaces for people because, right, these people are listed too. You got this originating company, the individual loan originator, and you got Miss Kim. There should be 3 different people that signed this thing agreeing to what happened. But that's not the way they did it. And then we find out that the lender has got this attorney firm, right, that is supposed to be the one putting together the paperwork, like the warranty deed and so forth. Note to close, please give Bauer 1 copy of this document, return signed originals to the office. Okay. Anyways, what they were doing in this deal is they were putting together the paperwork for the lender. Supposedly. Representation, right? The undersigned acknowledges the preparation of certain legal documents, including but not limited to a warranty deed. All right, now, what we saw was a general warranty deed. This just said warranty deed. It doesn't say general warranty deed. So this is probably a different deed completely. Right? A warranty deed, a note, deed of trust, possibly other documents, right? They're supposed to have put these together. They did all that. All right, and we'll find out why that's important here in a minute because, right, we're talking about now about the warranty deed preparation acknowledgement. Well, it wasn't signed by both parties, so it didn't happen. Authorization for residential service contract. Coverages, that didn't happen. What page am I on here? It's 115. Okay, I'm going to go to 119. We'll just click ahead. And then T47, residential real estate property affidavit. Right, not sworn by the seller. Got title company, we are the owners of the property, blah, 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 blah. You got places for the owner to sign. They didn't sign it. They didn't swear to it. Never happened. Kim acknowledged the fact that it was never signed by anybody, right? But this document was never executed. So there's no affidavit. Apparently it's important. It has to be there. But it isn't. Right, this Form T47, what if that's a state form by any chance? Okay, 119, we just did that. So 121. Yeah. 122, affiliated. Okay, this talks about some other people are going to get involved. I think it's this has more to do with like the warranty and so forth on the property, not the loan itself, and that's what we're talking about. We need to prove there's not been a loan. Okay, now this is interesting because here is another survey. Right, and it's got Kimberly's name on it. And it's got a house on it. Let's compare that to this one. See, on this one, where are you? On this plat map, there's no house. But on this map, there is a house. And it does have her name on it as the borrower. It doesn't say owner. But, we're one step away from saying, well, this is what she was buying. Okay, and it says that thereof recorded in film code number 6988887 of the map records of Harris County, Texas. Well, when Ms. Kim went and looked at that, that isn't what pulled up. It, was this other map that pulled up that had nothing to do with her property. But this is what should have pulled up. Right? Shows that she's the owner. So there was a survey done, right? So remember that was one of the things on the agreement that the buyer had to get a survey. Well, here's the survey. But apparently it's been misfiled because that isn't what you get when you pull this up. So we'll be getting on that on Monday. Outstanding. Okay, 141. What did I say that? Your loan servicer is Idaho HFA, not FHA, HFA. Who the hell is that? Originating lender. Got a loan number, the amount. So someplace. Because this loan number has changed now. This isn't the loan number they used before, right? I don't know if I don't have the damn. Yeah, I do. I got it right here. Right. They say this is the loan ID, a 93 number to start with. But apparently here the loan number starts with a 50. I smell a rat. 154. We're almost to the end. Okay. So here is, this is the closing document we looked at before. Right? The closing disclosure. Who's involved, who's doing what. But then all of a sudden you come here. All that stuff is gone by, and all of a sudden there's a page with the only thing on it is a signature. Right? It's page 3 of 3 of a closing disclosure. But what closing disclosure? Right? It doesn't make any sense to me. There should have been some place for them to sign if that's what had to be done. My point is, all of a sudden out of nowhere, there's one signature on one piece of paper. Certification of seller in a FHA insured loan, right? Got his signature. But when we get down here, this is page 2. Well, where's page 1 of this document? Certification of seller. Right? Because it isn't here. There's no page 1. What the fuck happened to page 1? Apparently they forgot to give it to her. So they got that. Then you got seller and or purchaser powers statement. I have carefully reviewed the HUD-1 statement. Well, the seller did, but the buyer didn't. So, again, we don't have all three signatures on one piece of paper. There ain't been a contract. You go down. Texas disclosure. 1 of 3. Real estate commission disbursement. Deed recording. Oh, hey, guess what? It wasn't signed. So, it's not a contract. This person, the settlement agent, did not witness both parties signing this piece of paper. So there you go. All right, that's just an example of what you find when you go look at the documents. And so in all this, I say, well, there's deceptive practices. And so carry on, go file a complaint into a petition into the small claims court, and go from there. See what happens next, because these people can't go there, because if they're found that the judge agrees that what was done was a deceptive practice, well, it was either a misdemeanor or a felony, and they have to go to jail. And if you can get that kind of judgment, well, now you get to get into their insurance money to get back whatever's yours, which is separate from the damages that you're claiming you're owed, right? This other stuff then that comes in the picture is like for cost and penalty and penal. Is it penal damages? Is that what they call it? They can add all these other things on once you get the judgment. The thing would be to get the judgment to say that they committed a crime. And because of that, I don't believe that all these people involved want to go to jail, so they're going to have to settle ahead of time. And in that settlement, well, you get back all your money and have the land given to you for the $10 transfer of the tax payment, right? Because basically you're claiming abandoned property. Right, put my name on that property. There's nobody's name on it. We'll put mine on it, and I'll pay the $10 for the certificate. And, there will be some taxes you have to pay because, it costs money to run the country. But most of what you pay in ad valorem tax has nothing to do with that. It's all these additions they put on there because we're not on the frickin' title. And it's all smoke and mirrors. They say, well, now you owe this and this and this. And they get you to go to the court where it's all by trial by wager of law, not trial by examination. They're not looking at any evidence in the court that you go to where you're represented by an attorney. They don't want nothing to do with it. Right? If you want to have the evidence looked at, you got to be trial by examination. And one of the places to do that then is the small claims court. But I think the place that you can do it against the state will be with like in our state, we have a state that's a court of claims court. Somehow, because I'm not going to get into it now, this is just deceptive practices, but they have the same thing with the government, where the government is has an act for negligent acts. But if you want to take them to court for a negligent act in Michigan, you have to take them to the court of claims. Which, that's another day, another story. I'm just, today I'm going to stick with one thing at a time, which is this, because we have all this fresh information. It's all right here in front of us. It's just now a matter of going to the court and complaining, going to, look at this closer. I think it looks like you go back to the title company, because they're supposed to be the closing agent, the escrow agent, and so forth, and complain to them that this stuff didn't happen. And find out if did the broker ever get paid? Which was one of the questions we asked, and they didn't answer all day yesterday, right? So it's been an avoided question. Well, did they get paid? The other one was sent to the title insurance company. Did this transaction close? They haven't answered yet. It's a simple answer, yes or no. We're still waiting for an answer. Which the answer is no, it didn't close. All you do is look at the paperwork, it didn't close. So that's where we are, folks. It's I think anybody who owns property needs to do this. You don't need to be in foreclosure. In fact, it's better not to be in foreclosure. You don't have that hanging over your head. Go do it now and claim that what happens is deceptive practice, and claim your shit back, and we'll destroy the banking system as it's known today, and the true banking system will appear. It's just hid by this smoke and mirrors that we're dealing with. Okay, very good. I'm going to stop there, and you'll have a great day. And if you've ever, I wish I would have said this earlier because at the end of the video, if you've ever been to small claims and won, especially against a company, please send me an email to courtofrecord@aol.com and tell me about it. I'd like to hear about it. Okay, I'm going to leave it there. You have a great day. See you.